Stanford versus Norman. Morning.
Morning.
Morning, Your Honor. Jim Kurji, PA 320 on behalf of the plaintiff, Bill Sanford.
Your name?
Susie Norman.
All right. And where are we on this case? Well, good.
Your Honor, I submitted a motion for summary disposition.
Did you get a copy?
I did via email.
Are you going to respond to that?
I have my response was a case that I had opened. It's supposed to go under Judge Barr. That was my response. And I came to the courthouse and wanted to file what I could. And the girls said there was a note on my case that said Judge Barr, I guess Judge Barr, I don't know. Someone wrote a note that you were going to look at that today and use that as my
Okay, right.
Counter,
Well,
since the cases were of the same people.
have you vacated the premises or no?
I have not. As you know, I have my job offer in Seattle, and I'm here because I'm still here in the city because I have to appear in person. So, and just trying to wrap this up.
So in regard to your motion for summary, why wouldn't I consider what she has filed in the other case as creating a genuine issue of material fact?
So, Your Honor, one moment. The crux of that case is that her property didn't have a certificate of occupancy. That was just brought to light recently as, I guess, a separate claim. Rent was ordered to be placed on escrow by the court. Rent has not been, only 1 month of 3 months rent has been placed on escrow with the court.
Right, but if there's no certificate, if there's no COC, how does your client even charge rent?
So, Your Honor, my client has been in touch with the city of Pittsfield and has been arranging to get the COC.
The city of Ipsy? Yeah, okay, that's fine. But how does he charge rent if he doesn't have a COC?
Your Honor, this is not a, we're not claiming rent. We're not claiming money damages for rent. We're just claiming for the possession.
I don't know what that means.
This is not a claim for money damages. It's just a claim to return the property. At some point, some rent is due because Ms. Norman remains in possession of the property.
But there's no COC.
Your Honor, the COC expired in March of this year. According to my client, the city of Pittsfield has told him they're shorthanded on building inspectors. That's why he didn't receive a notice. He's been in touch with them to try and get the COC sorted out. The number of things pointed out on the violations of the other case are things such as a permit for electrical outlets, permit for a water heater. There's no complaints in that inspection report of items that are not working. It's items that are not up to code.
Is there anything under the Pittsfield ordinance that extends it? Is there anything under the Pittsfield ordinance that extends the COC?
Not that I'm aware of.
There isn't.
But I have no control over them administering their duties as far as issuing those.
Do you have the council? Do you have the prior COC?
I don't, but I don't have it on me, Your Honor. But it was issued in 22.
With CVO?
Yeah. My client might have it on.
Give me a minute here.
Did you call to get an inspection?
I called the building department in regards to this matter. And they
No, prior to March.
no, I did not, because I was not aware that this was about to expire. Normally that process is
It's a 2-year certificate.
they send out letters saying,
Right, I understand that, but it's a 2-year certificate. So the question is, if she's paid rent through June,
Last payment was on 5/24. And I have a balance on the property of, to the best estimate, $19,845 in rent and $1,500 in water bills and other utilities.
19,000?
In rent due. Rent's $3,300. I have the last payment on 5/24 of $2,230. $2,230. I have a ledger based on the payments that were submitted in her other case.
Okay, but you have to get past the legal issue of how can if he if his certificate of compliance is expired, how does he charge rent?
Your Honor, so I believe that the rent being questioned would be the rent moving forward from the time in which that was brought to our attention. But that's correct, Your Honor.
From the time it's brought to your attention.
Yeah, from the time the issue's raised.
Pardon?
From the time the issue's raised, Your Honor, she signed the lease, she's made payments as if she were, as if there were a COC. Turns out there's no COC, we're not asking for.
From May through today, how do you charge rent if there's no COC?
I believe my client's in a position where he can't charge rent or that rent would be disputed.
That what?
That rent would be disputed and it's being disputed in the other case she's raised.
Right. I don't understand what you're saying. You filed a landlord tenant case seeking non-payment of rent, right? Seeking non-payment of rent, right?
Correct.
You can't, under what theory can your client charge rent if he has no certificate of compliance?
Your Honor, I don't have a theory right now as to a legal theory as to how he can do that. I have,
Well, then how are you going to go forth on this case?
the other option, Your Honor, is to do.
We would all agree that in order to charge rent or to rent property in Pittsfield, you have to have a certificate of compliance, right? We're all in agreement on that. He has no certificate of compliance. So how does he charge rent?
So, Your Honor, I think the answer would be that he can't charge rent until he gets a certificate of compliance. Or see,
Okay, so it expired in March. The rent you're claiming she owes is for a period after March through today. And from that period after March into today, he doesn't have a certificate of compliance. So how does one evict?
so Your Honor, we could go through with a 30-day notice, but my client has been undergoing efforts to obtain that COC. It's not as if he has just ignored the issue. He's been under the efforts to correct it, and he would like to correct it. The problem with correcting it right now is that Ms. Norman is in possession of the property, and he can't make repairs or has attempted to make repairs and been told
Has he attempted to make repairs?
that is.
I have tried to make repairs. There's been 4 times when I have sent a appointment to go over there, make repairs, and she has refused me to enter to make those repairs. So I can't make the repairs.
When is the township going over?
What's that?
When is the township coming in to inspect?
Well, they are claiming that they're come back in November 2nd or something. But.
Then counsel, if that's the case, why am I hearing this now? You have no legal theory upon which you can proceed. The other case is now my case. So I'm just going to consider it as a counter to this case. So why am I hearing it today if your client has no COC?
Your Honor, I heard it first at the last hearing, so I may have a moment to confer with my client.
This is why Ann gets a pure allowance on this stuff.
Thank you, Your Honor. We can agree to dismiss this at this time and move forward with under a different process as we try and as my client attempts to obtain a COC. The court feels that that's the best thing to do at this time.
I'm just trying to figure out how you're going to proceed. I think part of Ms. Norman's claim is that she's owed money.
So Ms. Norman has been in possession of the property the whole time under a lease agreement. Now, that lease agreement has an issue with the COC.
She cannot legally do because he doesn't have a COC.
So without more investigation into the COC and why that wasn't issued or what the issues are with the COC, I can't speak to the matter at this time. I've looked at the inspection report that was provided in the other case, and the items on the inspection report didn't appear to be items that would be interfering with the daily use of the premises.
You do understand this isn't about habitability.
Correct, Your Honor. My client has, if you had some difficulty obtaining.
What's that?
You had some difficulty obtaining COC report.
Well, they made an inspection and made this report. and they have another inspection lined up for the November 2nd. But if she won't let me go in to make repairs, I told the building department, because we're in the middle of an eviction, that I want to delay that till she lets me in. Will you make an order to?
Your Honor, I think he's saying until he believed he would get possession back and then finish the permitting of the boiler and whatever was on the inspection report.
When are you gonna let him in?
Problem with me letting him in, the first time, well, he comes over unannounced, and I've asked him not to do that. I've asked him to contact.
Okay,
me
Miss
via
Norman,
email.
give me a date that you're gonna let him in.
He give you a date when he could come in and repair? Or when, I'm sorry, I didn't hear you. My bad.
Isn't that what I said?
Is that what he said?
Yes, that's what I said.
I don't have a problem with him coming. I have a problem with him cornering me off, asking me when I'm getting out of there when this case is ongoing. He's done that twice. That's why I have a police report on my other case, because he just popped up unannounced, asking me when I'm gonna pay the rent, flashing the water bill. I talked to Cindy at the Pittsfield Township every time we have a court date, and he has me paying it. He's suing me for the water bill. I just let them know that I will, if whatever the ruling is, I will let them know if I have to pay it or if I have to pay him and he's gonna pay it. I don't have, so that's the only problem. He comes unannounced and he starts asking me when I'm paying the rent, when I'm putting stuff in escrow, when I'm doing this, when I'm doing that, and that makes me feel uncomfortable. So if he needs, and I know that the city has had, he said that they were backed up and couldn't come. I called them and they came for me to inspect it.
Okay. So I don't know why neither of you want to answer my question.
As I don't have a problem with him coming and doing his repairs, if that's what,
So what date can he come in?
whatever. I mean, he can give me a day. He's all over like, we've done this before, and it's like, you have to ask him. I will make it.
Okay, so what date do you want to go do the repairs?
I cannot say that it's going to be all in one day. There are several.
Okay, so what date do you want to start doing the repairs?
I will start later this week. I will come in Thursday or Friday.
Emily, if I said to you, give me a date for a case, would you just give me any date and just an approximation? No, because that's not what I asked, right? Yeah. So.
All right.
Glad we got it straight, because I was trying to figure out if that's how it worked. That's you.
I will do the work next week. Between Monday and Friday, I will.
So what date are you? Geez, oh Pete. Just
Monday.
what is Monday, Emily? 28th.
But I will also probably need to be in there other days. There's drywall repair that needs to be done. That cannot be done in one trip. I need to have inspectors lined up and scheduled to come in for their process. And I don't know what their schedule is and when I can get an inspection for them. It's not a one-day repair to get these things done.
Oh, no, I've seen the pictures. I realized it's going to be more than a day. So you're going to go in, start repairs on the 28th, question mark, right?
Monday, the 28th. I will plan on going in and doing all the repairs I can that day. There will be other issues that still need to be addressed with
You guys. Okay. When are you leaving? That was also a question.
I am leaving as soon as I don't have to come back to court anymore. I mean, can we do it in Zoom in Seattle? I just can't move from there to another spot and then to Seattle. The only reason I'm still here is because this case is still going. And the reason I'm here is
Okay.
seeing the pictures.
So
I mean, is this case going to be done after today? Is it going to be completed, finished?
at the rate you guys are going, really? Okay, so here's what I'm going to suggest. Can you guys talk to each other civilly without me?
I
Don't think so.
certainly think I can.
Your Honor, this case involved itself with possession.
What?
Case resolves itself with the city. Should Ms. Norman have be moving to or going to Seattle?
Except council, you're charging rent. You just told me it was 19,000 that you want from her.
Your Honor, what we want is possession. We haven't claimed, there's been no claim for money judgment.
So you're gonna waive rent?
No.
Okay.
Well, in this case, we're not asking for rent.
Wait.
Wait a minute.
Your Honor, my client agrees to waive rent.
Okay, well, would you agree to release the escrow to me so he can get possession? I can go and the case can be done today.
Wow.
As much as I like to be in this courtroom, this is my eighth.
Oh, I liked it until this morning.
What?
Look, here's what we're gonna do. You're waiving rent. You're waiving any claim for monetary damages.
Yeah.
Is that right?
Yes.
And when are you gonna leave?
10 days or less? I heard you said perfect. I'm not trying to stress you out, Judge.
You are not stressing me out.
Okay,
Trust
good,
me.
Good.
Trust me. I got a lot more. I got a lot of
Okay.
other things that stress me out. This is not one of them.
Oh, there's the bright spot.
Okay, so what are we doing? You waived your claim for rent. You're moving when?
10 days or less, and I can take the keys.
So Pete, give me a date. Just give me a date that you're going to leave.
What is the date today? The 22nd? October 31st.
It was the 22nd. It's probably the
October
25th by now.
October 30th.
What? October 30th. Will that work?
Do I need to get this repairs done next week? Or that's, can be done after she moves out?
Write up a conditional order of dismissal, waiving all claims for rent money. You can put both case numbers on it because if there's no claims for money, then that would resolve your other case, would it not? Amazing how I do this. Write up a conditional order of dismissal, look it over. She's gonna leave on the 30th and then come back and I'll sign it. All right, I'll pass the matter so you can write that up.
All right, thank you.
Come back already.
Today. Oh, no, you guys are not leaving.
In escrow.
What about it?
I'd like to have that.
Okay, if they've waived all claims for money, what do you think happens to escrow?
I don't assume anything. In nursing, we don't assume it. I can't assume it in your courtroom, sir. As long as it's written on the conditional dismissal, then fine. Can't assume anything. I don't know the law language. I don't know it.
Oh, I'm
Yeah,
aware.
I know. You can,
I'm aware.
the 8 times I've been here.
What?
I said, I know you probably gathered that the 8 times I've been here.
It's only been 8? Seems like 50. All right, go out, write that up. Escrow goes back to defendant, plaintiff on the other case, and then we can be done with this.
All right, thank you, Your Honor.
Thank you. Hey, do me a favor. Keep an eye on them because that's going to blow up. I don't know what's going to happen, but it's going to blow up. I want to call another one. I know. It's going to go better. Well, court does call the case of Finney versus Sidoni. All right. What's your name for the record?
Brooke Sindoni.
Your name?
Maria Finney. Good morning, Your Honor.
Good morning.
Peter Sindoni.
Brooke Sindoni.
All right. Okay, folks, where are we on this case? You guys can have a seat.
It's about the further investigation on the DTE.
I'm sorry?
DTE did investigation on the fraud.
On the bill?
So DTE, their investigation, they emailed me the things that they found out when they had the DTE connected under my account through Sindoni because I shut it off before January 2019. So there was a charge of $5, which is that's a charge to open it back again. But it was opened under it was created on an account. It wasn't it was created an account by iPhone, Apple iPhone, and they emailed me the template where it was open, which is this one, actually, where it says they open it through iPhone and they had the email of Sindoni in there to open that account. And then on December 23, 2021 is when I paid $2,568.49. And then I opened that account, which is my actual account, on 9/2 2021. That's one of the copy. And then DTE also investigated that my account. It says there, thank you for contacting DTE Energy. You recently requested a letter of a credit of regarding your DTE Energy account name and number, Maria Feeney, and then my DTE account. It says here that Maria Feeney has been a customer of DTE from 3/16/2016 to 11/02/2020 has an account balance of 0. And then they also, so they emailed me the template saying that.
So, ma'am, can I just stop you for a moment?
Sure.
The real question was, did they have an account in their name?
Yeah. No, they don't. The account that they were using is still in my account. That's what the DTE emailed me. And there's they made a budget-wise billing through them on my account. It says here, and it says that they use the DTE account.
So whose name is it in?
It's on my name, but they had it on their name. They opened it by putting the Sindoni iCloud in there. And may I show you this?
I don't know what it is. Well, no, hold on.
She's my sister.
Okay, that's nice. Listen, so the question is this, whose name is the account in?
My name.
Do you guys agree with that?
Yes,
Okay,
it was as of 12/1/2020. It was in her name,
in whose name?
in Peter and Brooke's name, because she shut it off on us. She interrupted services on us.
In 2020.
Yeah.
And then you got it turned back on by how? So in 2020, it went into your name.
So when we moved in, she had a previous balance and she was on a payment plan. And we took over that payment plan, and there's a text that we put in the.
Okay, that's fine. So folks, listen, are you guys still in the property?
No, oh no.
Okay, when did you move?
1st, 2021.
Okay. So from 2020 through 21, ma'am, you shut the electricity off, correct?
I shut it off because I told them I'm not gonna be responsible.
Okay, didn't ask all that.
In there, and it's too expensive to run it.
Okay, didn't ask all that. You shut it off.
Yes.
They turned it back on.
Yes.
They turned it back on in her name or your name? Well,
Sorry.
and then from the time you turned it back on to you vacated the premises, whose name was it in? Okay, and you're saying it was in your name?
Yes, because it's.
Well, the bill can only be in one name.
That's right.
Thank you.
This is what the DTE had sent me and said that when they open it in their name, like they said, it's still on my account, which is this one.
Because you're the owner of the premises.
Yes.
Yeah.
And then the $2,000 that I paid.
Ma'am, stop. You're the owner of the premises.
Yes.
Okay. So your name will be on it because they're renting. So if they all of a sudden just go, The bill goes back into your name.
Yes, but I paid so if it's in their name, they paid, I paid 2,500
When did you pay that?
and they tried paying
When did you pay that?
December 23, 2020.
2020?
Yes, it's right over here.
The bill was in your name at that time.
Yes. So I paid it. Well, it was in their name, they say, but DTE said it's in my name because it's in my account. So I paid DTE but they were trying to pay it before that and their account was declined through my DTE payment history. It says here that it wasn't authorized.
Well, ma'am, what do you want in this case?
They have a rent that they didn't pay. And
Of how
when
much?
they were paying the rent, it was going to.
How much rent do you claim they didn't pay? Okay, I can't see over there. Show that to them. Oh,
That's for the rent, Your Honor. That's not for DT.
I know. That's what she said.
Oh, yeah, them are all paid from our account. Yes, them paying directly from our bank account, paying her mortgage.
Yeah, any payments that were made, we did submit to the court, they're already.
And we paid the rent in full.
You know what? I'm gonna get up and walk out. I'm just gonna get up and walk out. You come back and try this again. So you're claiming that they owe you $9,278.15.
Yes, that's not mine. They were forwarding all the rent to 14th District Court, just the escrow. And it says here, the defendant are being paid on August 31st, 2021. If they are not out of September 1st, we will move forward with a judgment of immunity.
Okay. How much do you have?
And then must pay August rent.
$5,263.17.
I too.
63.17.
Okay. So in terms of rent, folks, how much do you say you owe?
As you just said in the last case, she had no COC on Pittsfield Township on the house. She can't collect rent.
You didn't raise it.
Can I?
Oh, go ahead.
So the reasonings for the rental not being included now in this, and the money matters being part of the insurance proceeds and other things such as the DTE, is because of the wrongful eviction attempts. Said being the shut off of the electricity while we were in the home. And that was the reason, that is the amount that she keeps trying to say that is due, was because when she shut off the electricity on us, that amount came through our account and we got it back, but that amount was from when her account was on payment plan. We do have documentation that we paid.
How much rent do you claim or think you owe? You think you paid everything? So when I look at her ledger sheet, it doesn't include payments that you've made?
So we have are from the mortgage company.
Didn't ask that. Can you make me a copy? Make me a copy of this. Yes.
October 15, Wednesday, I was busy with my papers and everything, and I got a text from Brooks and Donnie saying that, you better have your pictures that we don't have. And I didn't know who texted.
What are you talking about?
I called her.
What are you talking about?
She called, she texted me while I was working on my papers on October 16. She was telling me.
Your Honor, she filed paperwork with the court stating that we owed a amount of $2,900 on 12/30 in 2000.
So, Mr. Slindoni, you think that if you just overtalk somebody that makes your point more important?
No, not at all.
Okay, then why'd you do it?
I'm sorry. I didn't know anybody was talking.
Seriously? Give me a copy. This is ours.
That's what I'm asking. You wanted a copy for file?
Yeah, well, they need a copy. Here. Give that back to her, and then I need a copy. No, You guys, I'll tell you what I'm gonna do. I'm gonna take care of these other two. And then you guys are, I'm going to then get up and I'm gonna leave and I'm gonna come back. In between that time, you guys figure out how it's supposed to happen in a courtroom where you guys can't talk over each other. You answer the questions that I have, and then we can proceed in that way. And we get that. Now I'm gonna ask one question, Sidonis, before you leave. That ledger that you just got, do you have other payments that you've made? I'm assuming as you're shuffling through those papers, that's a yes.
Yes.
Okay, then you go out and you figure out what other payments you have.
Thank you.
I can do the math. All right, so I'm gonna pass this matter. Stanford versus Norman, Norman versus Stanford. Allen, do we have a conditional order dismissal?
I know that it's at least 1,100. The last bill that came
It
out.
was 1,500. It was 1,500 when I walked in.
It's 1,100. It's 1,100. And because of the leaks in the house, I'm having that evaluated. But that's how much it is now because they bill every 3 months.
So when's the next billing?
Well, the billing is, I'm not sure it's set up on quarterly. I believe it is. I'm not exactly sure.
You got the bill and came over and waved it in my face. You should know.
Is that really necessary? Was it necessary?
No,
Was it necessary?
no.
Then don't let it happen again.
This one was a due date of 10/2. It was $1,058.17. And it is every 2 months.
Okay. You're agreeing to pay the water bill, whatever it is, through the 31st. You can call the water company and you can get it so that the 31st is a date they can tell you how much you owe. Okay?
Okay, Your Honor. Thank you.
So here's what I'm going to do. I will release the escrow to the defendant, but I really don't want you guys back. So I'm going to hold the escrow until I can get a final water bill. Then pay the water bill to the plaintiff. The balance will be returned to the defendant.
Thank you, Your Honor.
I don't understand.
Okay. Let's say the water bill comes up by the end of this month being 1,500. And that's what I heard. All right. Let's say it's 1,500. They will get to me that final water bill, right? And then what I would do is I would send them the 1,500 as though you're paying it, and then release the rest of the escrow to you.
Okay, we'll have to wait till the 30th. Yep. I have to
Till
get
you
the bill
move.
for the 31st.
Pardon?
I have to get the bill through the 31st or through now. And you just take the money out of that and pay that bill. That was due on 10/2. They're not gonna have a final meter read because they want to change the meter anyway. It's from 1998.
Need a reading as of the 31st. Whatever that reading is, the water company will go through, they'll figure out what's owed through the 31st of October. That amount will be deducted from the escrow and will go to the plaintiff, right, to Mr. Stanford. The remaining part of that escrow will then be paid to you. Anybody unclear as to that?
Makes sense to me.
I'm clear, but
But what?
I don't think they just, never mind.
You don't think they just what?
Never mind. They must read it at the building.
Get a final reading as of the 31st. Otherwise, what's going to happen is I'm going to just wait till the next bill comes out in 2 months. I'll prorate it myself.
Fix that water.
I'm just going to add to this that the escrow is to be released after presentation of final water bill. All right. So what I'm going to do, folks, is this. This resolves this case. And what I have here is that plaintiff is waiving any claim for rent. Defendant agrees to return possession to the plaintiff's owner before October 31st, 2024. Escrows to be released to the defendant. The defendant, however, agrees to pay the water bill through October 31st, 2024. I've added language that escrows will be released after presentation of final water bill to the court. Everybody understand that?
Yes, but I could use that escrow for moving.
Yes.
I have 5 people to move.
Okay, so you don't want to agree to that? When is the water bill going to be paid then?
Pay it out of the escrow, that'll, of 1058. That'll take care of what's due now, that was due on the 2nd.
Then what do we do with the period from that 2nd through the 31st?
I
You
will,
realize, ma'am, that water bill becomes a lien on the premises if it's not paid.
I do. I,
Okay, so it's somehow or another, it's going to need to be paid.
that last portion I will pay. That last portion from the 2nd to the 31st.
You guys figure out what you want to do because the money's there. I told them to get a bill. You don't want to do it that way. I can't sign this conditional order dismissal. I don't know why you two can't come to some type of rational understanding of how this is going to be done. If you guys want to sit in here all day and fight it out, fight it out. Court's in recess.
District Court for County of Western State of Michigan is now back in session. The Honorable Judge Jay Cedric Simpson presiding.
You may be seated. You guys work out. Let's try it again for the 3rd time. Stanford versus Norman.
Ms. Norman and I have, we've come to a clarification on the consent order. Plaintiff is going to waive any claim to rent. Defendant agrees to return possession on or before the 31st of October, 2024. Plaintiff and defendant agreed to split the $3,300 escrow in the following way. Plaintiff is to receive $1,500, the defendant is to receive $1,800.
Plaintiff gets 1,500. Did you write that up? Ms. Norman, is this your understanding?
Yes, it is.
Do you have any questions regarding anything contained on this conditional order dismissal?
I don't have any questions regarding that. I do feel like I'll be back to see though,
Damages.
but
Underlying which in,
I understand that and I signed it and there it is.
well, but that's going to get rid of this case also. That's why I had you put both case numbers on. I was trying to resolve all these cases. So is that your understanding, ma'am?
Yes.
Just going to add a provision on here that case ending in 3728 is dismissed as part of this. Do you have any other questions regarding anything contained on this? All right, you do have 3 business days to think about this. If you have any, if there's any legal reason, any misunderstanding, any non-assertion of rights in this matter, you'd have to file a motion with the court. That doesn't mean that I would grant the motion. However, you do have those 3 business days. You understand that, ma'am?
I do.
Case ending in 2445 is conditionally dismissed, and I've signed the order. You can pick up a copy up front. The other matter is dismissed. Thank you. River Ridge versus Timothy Kelly. My goodness. State your appearances, please. Your name, sir?
I'm Tim Kelly, yes.
All right.
Sorry, Your Honor.
No, not a problem. Ms. Dornbush, you guys can have a seat. Ms. Dornbush, it is indeed a pleasure seeing you actually in person and not in a little box on my screen.
Yesterday that my last appearance in your courtroom was the last day we had in-person proceedings before COVID. This Friday, we were in this courtroom because we had to.
Had to go back and forth.
Yeah.
Amazing.
Yes.
It's been a while. Yes. Okay, so where are we on this case?
Today is the date and time for, I think, a settlement conference.
Yes.
As of the last date, Your Honor, given plaintiff an opportunity to file a reply to Mr. Kelly's answer, which got done, setting forth deficiencies in the answer, what I would call admissions in his answer, additional grounds on which the plaintiff has to terminate Mr. Kelly. The most serious of which, Your Honor, is based on the revocation of Mr. Kelly's driver's license, which I believe occurred in 2022. And he's certainly been driving his car in the community over the last 2 years, and that violates Michigan statute and rules and regulations. Clearly state that a violation of Michigan statute or any other ordinance, local, state, or federal, is grounds for termination of the tenancy. So I don't know that there's a tribal issue in this case, Your Honor. For that reason, we would be asking for a judgment session today.
I can't hear a word she's saying. I'm sorry, Your Honor. Like 40% hearing, trying to get a hearing aid right now. Appreciate it. Sorry.
You're different than her.
Like this?
Oh, no.
Like this. Got it. Sorry. That's much better. Thank you.
I was going to have you do it the other way. Sit here and laugh. Anyway, all right. Could you briefly surmise what you just said, Mr. Wong?
Yes, no worries, Mr. Kelly. To defendants answered our complaint permanent. In our reply, we did set for several deficiencies in the answer, as well as the additional grounds on which plaintiff has to terminate Mr. Kelly's tenancy. The most serious of those additional grounds is revocation of Mr. Kelly's driver's license in 2022. Has most certainly over the last 2 years been driving his car in the community, presumably without a driver's license. And rules and regulations and community is required to abide do indicate that violation of Michigan statute or any ordinance is grounds to terminate driving in the community without a license or violation of the lease agreement. And for that reason, I don't believe there's a tribal fact here. I do believe plaintiff is entitled to a judgment of possession.
Your response, Mr. Kelly.
Your Honor, none of that was brought up in the initial complaint back in July. She hasn't brought up one thing that the original complaint stated. So, you know, I don't know where the laws come in as far as my license and everything, but.
Pardon?
I say I don't know where the laws lie as far as I haven't researched anything in the Michigan state statute or the community guidelines that mention anything about driver's license. That's because this is the first I've been accused of that. I mean, it's all the first time it was brought up, and that recently happened, and I don't have to own my car anymore. So
What recently happened?
That my car was taken away or impounded, not impounded, repo. Go ahead, I'm sorry.
I may reply to that. Your Honor, our reply to defendant's answer does set forth the ongoing grounds listed in the original demand for possession, which Mr. Kelly failed to respond to several of those. In his answer, Your Honor, very vague responses to the complaint for possession. 1. 2, Mr. Kelly does not respond to the claims that he was part of the law and that he's been disturbing other residents and that he has verbally abused the threat management and their personnel. Doesn't respond to that at all in the complaint. He makes no statement in support of his claim of retaliatory eviction. The original demand for possession, Your Honor, does state that we would rely on those being specifically delineated, but it also indicates that we would rely on any other violations that he becomes aware of at the time that this demand was issued. Plaintiff was unaware of ongoing issues with Mr. Kelly not having a driver's license. And so now the plaintiff is aware of those, they are going to be relied upon in this case.
Did respond to those as calling them false. I mean, there isn't one statement there. I didn't know if that should have been brought up with my answer or brought up in the trial, negate those accusations properly, because they don't stand up to the truth. None of them. So I did state that in the answer.
Your Honor, the Michigan Court Rules MCR 2.111A require a clear and concise answer. Same rule, subsection D, requires the defendant to state the substance of the matter he's going to rely upon in defending a complaint filed against him. 2.111F requires defenses to be pleaded. It also indicates that allegations that aren't addressed are deemed as admitted. Because Mr. Kelly did not specifically, he doesn't make any specific statements at all regarding claims against him. Again, a vague assertion that they're false, but how are they false? There is nothing in his answer to support his claim that these allegations are false.
I did go through each step that they were claiming and disagreed with them. I mean, I thought that's what the answer was supposed to be as far as the state guidelines and the community guidelines. I didn't know I thought that would be brought up in trial when I could bring evidence.
No, sir. That's not how it works.
If I just answered that these aren't true, each one, yes, I mean, I don't.
Well, you have to specifically lay out what your answer is, not just some general denial of everything.
Well, I don't see anything true about it. It's, you know, it's under the guise of upon information and belief. it's just hearsay when the bottom line, so I didn't, I don't have a lawyer, I can't even afford a lawyer, so I'm trying to do it myself, Your Honor, but all that, I have phone numbers and all kinds of things that you could call if you want to verify my reputation as a,
When did you stop driving? How long has it been since you haven't driven a vehicle?
I'm getting my license back to the state for quite a while.